Okay, Mr. Campbell, we are live and ready to go when you are.
Okay, thank you. Everyone will have to bear with me tonight. I've managed to catch the crud this weekend while I was in Soldovia, so haven't had anything in a couple years. And now for tonight, where I got to do a lot of talking, unfortunately, you're gonna have to bear with me here. So, all right, welcome everyone. We're gonna go ahead and call this meeting to order. So, a special meeting of the City of Soldovia Board of Adjustment. This is a special meeting regarding the appeal of the Soldovia City Council's decision denying an application for rezone. And Liz, if you'll go ahead and lead us off in the Pledge of Allegiance, please.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, thank you. We'll go ahead and do roll call for the record. Rojas.
Here.
Kennedy.
Here.
Peyton.
Here.
Keithley.
Here.
Langbart.
Here.
And Barber.
Here.
Okay, we have all board members present this evening. And at this time, we'll go ahead and let's see, we'll move on to our agenda approval portion. Just for the record, only those matters on the notice agenda may be considered. The agenda will be approved by consensus of the board. No item may be added. Items may be deleted. Question, Madam Clerk, have all the public notices been posted and sent to the parties and the adjacent property owners?
Yes, Mr. Chair, all the notices have been posted and sent.
Okay, with that, then I'll go ahead and look for a motion to approve tonight's agenda.
Mr. Mayor,
Yes.
make the motion to approve tonight's agenda.
I'll second that.
Okay, we have a motion to approve tonight's agenda by member Peyton with a second by member Langbart, I believe. Any additional discussion on the agenda before we vote? Okay, hearing none, we'll go and vote on the approval of tonight's agenda. All those in favor, Rojas?
Aye.
Kennedy?
Aye.
Peyton?
Aye.
Keithley?
Aye.
Langbart? And Barber?
Aye.
Okay, motion is approved with 6 in the affirmative. Tonight's agenda has been approved. We'll go ahead and move on to the new business portion, and this is going to be item C of your agenda, which will include an opening statement by myself as the chair of the Board of Adjustment. This Board of Adjustment hearing will be conducted in compliance with the City of Soldovia Code, reasonable regulations of the board, and other applicable law. The Board of Adjustment is a quasi-judicial board. The hearing is public, is being recorded, and being live streamed to the city's YouTube channel. All persons presenting evidence and testimony shall do so under oath, administered by the city clerk. This hearing will be conducted less formally with regard to rules of evidence and other court rules of procedure than in a judicial courtroom. This hearing before the board is de novo. The board will review both the facts and law presented during the hearing and submitted timely. New tangible evidence not timely submitted to the city clerk will normally not be admitted. All evidence considered in this matter should be in the record before the board as previously provided to the parties. The appellant or party applying to the board has the burden of proof to show entitlement to relief. Members of the public may have 5 minutes each to address the board prior to the beginning of the party's presentation. Each party will be allowed 30 minutes to present its case. During the party's presentation of the case, the parties may call witnesses. Cross-examination will not be allowed during the party's presentation of the case. Any witness that testifies during the presentation of the case, either by either party, unless excused by the board with concurrence of the parties, must remain available to be called during rebuttal, at which time cross-examination may occur. Each party will be allowed 10 minutes for rebuttal. Any requested revision to this agenda or procedures by a party must be made to the board and approved by the board immediately following the conclusion of this statement. Upon recognition of the chair, board members may question the parties and their witnesses. Questioning by the board may take place at any time before the hearing is closed. Questioning by the board and responsive answers will not count against a party's time. The board requires a quorum of 4 and a majority of the quorum to make a decision. The board may reverse, remand, or affirm wholly or in part, or may modify the order, requirement, decision, or determination as ought to be made, and to that end shall have the powers of the body from whom the appeal is taken. The board may undertake deliberations immediately upon the conclusion of the hearing on appeal, or may take the matter under advisement and meet at such other time as is convenient for deliberations until a decision is rendered. This is an appeal to the Board of Adjustment of a Seldovia City Council's decision denying an application to rezone waterfront resub number 1, lots 2 through 4, block 13, from commercial business district to waterfront commercial residential district. And I'll go through a couple bullets here of the timeline for everyone. A completed application for rezoning was submitted by 3 property owners as per Seldovia Municipal Code 18.97 on May 11th, 2024. The Seldovia Planning Commission held a public hearing on the application on July 24th, 2024. The recommendation was forwarded to the Seldovia City Council, and ordinance 25-02 was introduced, amending the zoning map. As per Seldovia Municipal Code 18.97.010D, the Seldovia City Council may or may not adopt the amendment as a city ordinance. Ordinance 25-02 failed to be adopted after public hearings held by the City Council on September 9th, 2024. The application was sent back to the Seldovia Planning Commission to be denied. The Seldovia Planning Commission sent a request for reconsideration with additional information on January 22nd, 2025. The request to reconsider also failed. The City Council directed a memorandum outlining their considerations and returned it to the Seldovia Planning Commission to close out the application. The Seldovia Planning Commission rendered a non-decision on February 19th, 2025 for the application to rezone. On February 24th, 2025, the City Council issued the denial in order to close out the application. Accordingly, we have allowed the zoning applicants an opportunity to appeal directly to the Seldovia Board of Adjustment. We have received no opening briefs from either party. The applicant appellant substantively participated in the commission hearing, but did not file any briefing. Okay, so that's my spiel. That's going to take us to item D. At this point, this will be public comment. Members of the public will have 5 minutes each to provide public comment. And at this time, is there any member of the public that wishes to comment either in person or signed up online?
We do have one person in the room.
Okay.
They've not previously signed up, but if you'll allow it.
Yeah, if they're in the room, that's fine.
Good evening, Walt Sonnen. I live adjacent to the question or the property that's being disputed. I have in your thick packet, I have written a letter some time ago, and my opinion hasn't changed since then, and I might highlight that. The several points. I've spoken with a number of people that were on the commission that established the 2014 plan, and I don't think, well, I haven't spoken with no one who conceived that these three properties would be changed from their original commercial status to a status commensurate with those properties along the slough. These properties were built on land that was acquired through the city redevelopment after the earthquake on Shot Rock and facing the harbor. I think the overriding reason that concerns me is that the hurdle for rezoning, I think there's 7 different things, and the last one addresses the how does this serve the public? Is this a good thing for Seldovia? And I think that although it may satisfy the current owners of the property, but if we look down the line in another 20, perhaps 50 years, that these properties will certainly be valued as commercial properties. And I have to think that, you know, after we're all gone, that should these properties be zoned residential commercial, that people will look at us on this day thinking, what were those people thinking? Anyway, that's my input. Thank you.
Thank you, Walt. Liz, do we have anyone else that would like to speak or online that would like to speak?
Nobody else in the room. Mr. Stranick had said he wanted to comment online.
Can you hear me?
Yeah, loud and clear. Jerry, go ahead.
Yeah, here we are a year later, and going over the same things. A lot of time, effort, and money has been spent on this, and I still speak the same thing that I've been here over 50 years, and when I came here, there was 3 bars, 3 churches, and 3 grocery stores. Now we have 1 bar, 1 church, and 1 grocery store, and it's not looking good. And my premise is that make it good for anybody who wants to establish a business and make it work. And you can change things later if you want, but I think that that's the basis of the whole argument. A lot of people spent a lot of time out throughout the winter. The planning commission's work done, and that was, and then the zoning commission voted twice to approve of it, and it was turned down both times by the city council. Granted, it is a place that does have commercial value, but if there's no commerce, but actually you can have a business either way. So when business becomes more profitable, naturally it will turn to business because it's more profitable. So I fail to see why. Also, the other point is, in looking back through pictures of 1962 to 64, when the breakwater was in, and the canneries were still there, this was still called the SLU district. It wasn't ever part of the commercial district. And so I was saying that, you know, historically is an event. And now there's move on to change the rules of everything to where they don't go by the borough's plan that was sustained back in those days. They're changing it. So my point of view is that whatever we need in this town to make it prosper better, I think you have to look at every reason to do it for it rather than against it. And I rest my case.
Thank you, Jerry.
Looking at that, I do not believe we have any more public comment.
Okay. Thank you, everyone. That'll take us down to item E, and this will be swearing in of all persons that will be providing testimony. Let's see, all parties have standing pursuant to Seldovia Municipal Code, section 18.92.020. And if any of those parties are present, please identify yourselves to the board.
Yes.
All right, everybody could turn their mics on. And everyone could rise, that's provided testimony.
And raise your right hand. Do you swear or affirm the testimony that you give in the case now before this board to be the truth, the whole truth, and nothing but the truth?
I do.
I do. Thank you. You may be seated.
Okay, and for the record, that was Leslie Martin, Walt Martin, and Heidi Gagel were those three. Okay, we'll get on down to a couple preliminary issues regarding conflicts of interest. Do any of the board members have any potential conflicts of interest that they wish to disclose? And then this would also include any ex parte communications that have taken place between any of the board members and any of the applicants prior to this meeting. Okay, I will, hearing none, I will go ahead and at this time, Ashley, I would like to go ahead and pass the gavel to you. I do want to declare an ex parte communication. And in my discussions with the city attorney, the way I understand it is that if any of the board members or myself had any discussions about this subject with the applicants prior to this, and this was obviously before even having knowledge it would go this far. Last year, I had met with both Walt and Leslie, I believe twice at their place of residence to basically listen to their arguments on why this should move forward. So, and at the time, I met with them, listened to everything they had to say, and then obviously took it under advisement. And then since then, we've had a number of meetings. So, just want to get that on the record, and that's what I've got. And just to be clear, myself, I will not, the way I understand, this is a new process for us. We've never undergone this, but I will not be voting unless there is a tie similar to our council meetings. and the way those decisions are rendered. If there's a tie, then the chair would be the tiebreaker.
Good evening. This is Joe Levesque. I'm the city attorney. And what I would ask the mayor is there anything in those communications, those ex parte communications that you had with the Martins that would make your decision at this point? Or are you willing to listen to all of the evidence, the record on appeal, and then render a decision?
Absolutely. Yeah, no, I have no predetermined outcome, and absolutely willing to listen to all of the evidence and testimony before making a final decision.
Yeah, this is the city attorney again. Board member Keithley.
Keithley.
The board chair, having said what he said, it seems that any ex parte communications that he had have no effect on his decision making, and therefore the ex parte communication would not in any way conflict with him participating in this hearing.
Okay. So am I passing the gavel back to him?
You may just want to say you rule the same for the record.
Okay. I rule the same for the record.
All right, thank you, Member Keithley. And thank you, Mr. Levesque, for providing some guidance on that. Yeah, everyone will have to bear with us here. This is a new process, and so I want everyone to just be a little at ease here. We'll go through this, let everyone say what they need to say, and yeah, we'll get through this. So, all right, let's see, other preliminary issues. Are there any other preliminary issues which the board should consider before we get started? Does anyone have any concerns? Questions, comments regarding this process?
This is the city attorney again. Board chair, I believe that is open to the participants. In other words, if you have any motions that you want to file or any other preliminary concerns that you want to bring up to the board at this time, now is your opportunity.
Okay, hearing none, we'll go ahead and move on here. If either party has witnesses to participate in the oral arguments that have not yet been sworn in, please identify them now. And we did have, so far, the only additional witness was Walt Martin for Leslie Martin. Looks like we've got everyone covered.
That's correct, Mr. Chair.
All right, and then last little bit of information before we get started here on oral arguments. Members of the board may ask questions at any time during the oral arguments. So basically we can have a back and forth dialogue here while it's fresh in your mind. The agenda for today's Board of Adjustment appeal hearing sets forth the times that each party will have to present their respective arguments, including opening statements, rebuttal, and closing arguments. Do either of the parties have any objections to the time allotted?
I don't.
Okay. Heidi, any objection from you?
None.
Okay, and just to be clear, the appellant, which is Leslie Martin, has 30 minutes for her opening. The appellee has 30 minutes to respond. Then we have an appellant rebuttal, which is Ms. Martin for 10 minutes, Ms. Gagel for 10 minutes, and then closing arguments, Ms. Martin for 10 minutes, and then closing arguments for Ms. Gagel for 10 minutes. All right.
Can I
Maya, can I ask a question?
Absolutely.
Me being the appellate, can I yield some of my time to Walter? Or are we co-appellants, or is he considered a witness or whatever?
Yes, I believe he can, and maybe the city attorney can clarify that as a witness. Yes, the way our code's written, he can help you all through this, I believe.
City Attorney Joe Levesque, that's correct. The way the code is written, you can have anybody represent you. And so we understand that you're going to be providing some testimony, but you may have Walt Martin also
Okay.
provide testimony.
Thank you.
Perfect. Yes, great question. And thanks, Joe, for clarifying that. Item B2 here, the Seldovia City Code Section 18.92.060B provides that all appeals must be decided by the agency with whom the appeal has been filed within 60 days after the appeal has been filed with the agency. However, that provision of the code would be impossible since the city, rather than set an immediate public appeal hearing to meet the 60 days, allowed an extension to Ms. Martin and set the hearing date for May 21, 2025. Accordingly, the board intends to issue its final decision within 30 days of the date of the public hearing and hereby relaxes that time provision. Are there any objections to the way the board is proceeding?
No.
Okay, great. Thank you. I want to remind the parties that this is not the time for you to offer new evidence to the board. You must base your case on the evidence and the record on appeal. Okay, and at this time, then I believe we will go into a staff report and that's item F on your agenda before we get started with the testimony. And
Chair Camp,
yep, go ahead.
there is no staff report other than the record on appeal. That is the staff report.
Okay, and then obviously everything was in the, all other documents are in the large packet that was provided.
Correct.
Okay, all right, we'll move on down. We'll get started here with item G. This will be the appellant. Ms. Martin, you may proceed as the appellant. You have 30 minutes if you need it. Under the code, you may have someone else represent you. Is it your desire to have Walt Martin representing you as a portion of your 30 minutes?
Yeah, I'm going to yield my time to him when I get done.
Okay, nope, that sounds great. You can go ahead and get started.
I basically just have a statement, kind of reiterating what I've been feeling now as everything has gone over past a year almost. And it seems like the best interest of the public seems to be what everybody's talking about most in this whole process. And there doesn't seem to be a consensus from anybody in the community. And I can guarantee you that there will never be a consensus on this. So in my estimation, that the planning and zoning comes in because of that. And it's their job to wade through ordinances and protocol and to get the heart of the application set before them and have a recommendation to pass it or not. I would think that their determination would hold some weight if they've looked into the merits of the application and found that it was sound. For the council not to accept their findings is strange to me. What if it's more than logistics? What if it's more of a personality conflict? For the council to set aside the planning and zoning's determination and also disregard the comprehensive plan and the Alaska state statute seems to be put everybody in a precarious situation. In the original objection letters and some of the statements from the public, they suggested that I'm trying to relieve myself of obligation and trying to release myself of commitment. That sounds very demeaning to me, and it speaks directly against my character. The letters and comments overstep boundaries as well, in my opinion, trying to advise me on what type of business I should put there. If I should have a restaurant or a bar or an inn or a combo of some sort. Someone thought I should put in another shop like the Salmonberry, none of which sounds sustainable to me. They were speaking into my life and suggesting my character had some flaws and talking about things they had no knowledge of. It seems a lot of talking is going on out there without anyone knowing the whole picture. None of those people ever talked to me or had a clue about what my plan was here, yet they felt free to speak into my life without regard. Some of those people have been guests in my home, and some of them I thought were sisters in Christ since we went to church together. I think we should take the personality out of it. How about we abide by the comprehensive plan, the Seldovia Municipal Code, and the Alaska State Statute, and just to be on the safe side, attempt to be law-abiding citizens. I also wonder if there's a financial reason for the no vote, since Ms. Rojas mentioned something to the effect of that in her objection letter. She was concerned about the removal of a revenue stream and that the rezone would be of a great financial loss. And I'm not sure what that means, but I do know that I pay $50 more a month in utilities than my neighbors across the street that are zoned commercial residential. The removal of the revenue stream seems like a stretch, since there has never been a stream, revenue or not, coming from 173 Main, and therefore can't be that great of a financial loss. And due to this long battle for the last year, there won't be any revenue to the city for me. I have no plans to complete the project I had intended. The project definitely would have brought tax dollars to the city of Seldovia. One more point I would like to make in regarding to conflict of interest in this proceeding. It seems like a huge conflict that Ms. Rojas wrote a very detailed objection letter to my application for rezone and then went to vote on the outcome of that same application. I was told by Heidi that there was no conflict since no money or favors were involved. Maybe not legally, but there was a moral component to it. It's kind of unnerving to think that you have an unbiased counsel that is there to render a fair ruling when really we don't. I want to believe that buying a deteriorating home and bringing it back to life would constitute being in the best interest of the community. Thank you. I yield my time.
Hey, could we stop that clock for 1 second? I have a little conflict with one of your rules.
What do we got? Well,
On new evidence, under your ordinance 18.92.060, paragraph E, new evidence, it says may bring new evidence as necessary and may dispute evidence. And that's a direct conflict because some of what I'm going to say might be a little bit of new evidence. And according to your rules, I think I have the right to do it. According to the city's ordinance.
Mr. Mayor?
yes, go ahead, Joe.
Yeah, this is City Attorney Joe Levesque. So the purpose of this hearing is to go by the record on appeal and listen to any testimony that's about to be given. If any of the parties present new evidence, I would recommend that the board allow the new evidence in, but give it the weight that it deserves, and then decide whether or not that new evidence should be considered in rendering its final decision.
Mr. Mayor,
Yeah, go ahead.
can you clarify what you mean by the body deciding whether or not the new evidence bears weight or not? Can you clarify for me what you mean by that statement?
Well, new evidence would be any evidence that was not presented to the Planning and Zoning Commission, because most of the record on appeal is from that hearing, that initial hearing. And if there's new evidence that wasn't in the record on appeal, that would be new evidence. I mean.
So I'm just wondering how it is we are determine whether or not the new evidence submitted tonight bears weight or not. What do you mean by that? How are we deciding in this process whether or not it is admissible evidence?
Right. City Attorney Joe Levesque. So we made it clear that the record on appeal is the evidence. during their testimony, if they bring in new evidence, then the board gets to consider that evidence and give it the weight that it deserves. In other words, the board may decide that that evidence doesn't really get a lot of weight because it wasn't before the Planning and Zoning Commission.
Thank you.
Well, this is Walt Martin again. I am reading from your code book, by the way, not mine. This is your city ordinance. Something's changed between now and there, but if that's okay, I'll start the clock and I'll go ahead and proceed.
Yeah, that sounds good.
This is the city attorney, Joe Levesque. Mr. Mayor, or Mr. Chair, if I may.
Yeah,
So
go ahead, Joe.
there was an opportunity to present new evidence, but you had to submit it by the 14th. And that's in the correspondence that you received from this.
I understand the correspondence, but I'm reading directly from your ordinance. The only thing that required extra time was the attendance, who was going to speak. If you read it right now, it says you can bring any evidence as necessary to this hearing. And I don't want to argue the point. I mean, I'm not a lawyer, but I can read, and I'm just saying that's what it says.
So I certainly don't want to argue either.
Yeah,
but
so I'd like to go on.
But I'd like to just say, just to make the record clear, that it's unfair to the other party that's participating if they never saw the evidence. And that's why we set a date that if you have new evidence, please submit it so that the other side, your opponent, can actually see that evidence and prepare to deal with that at this hearing.
I'm ready to proceed there.
Yeah, go ahead, Walt.
Okay, City Council. I trust you're acquainted with this. We've just about wore it out. This is a comprehensive plan. I'd like to share some of the comments that were made referring to this comprehensive plan during a lot of your hearings that I watched on video. And some of them came out of that committee meeting from one of your council members. This is just a wish list. We don't have to go by it if we choose not to. Some of this was a mistake, referring to those 3 lots. This was written by folks that don't live here. The page 33 was a compromise so we could do other things. That came from Ms. Rojas out of the committee. It needs to be revised. The borough has $50,000 if we match it to do a new one. These are just some of the comments I heard watching your videos. I want you to read something on page 1 of the comp plan, and I'm going to read it to you. This document also provides the legal basis under state law for adopting land use regulations. This wish list is a legal document, whether you know it or not. It says it's a legal document. The plan is clear on zoning these 3 lots in your own map. The state statute 29.40.040 states that the assembly shall amend the zoning map accordingly. By your own Seldovia Municipal Code definition, the word shall means mandatory. I picked that up in your Seldovia Municipal Code. In one of your meetings, if my memory serves me correctly, the city manager, when asked about complying with the state statute, answered, "There's nothing that compels us to do so." In other words, there's no penalty if we don't. And I stopped the quote there. I would hope that all of you are law-abiding citizens. Wouldn't that alone compel you to follow a state statute? Some facts I'd like to share with you. In an agreement I made when confronted by Randy, your zoning chairman, in the middle of the Bay Street in front of my home. This was right after the last time I came to see you about a year ago. I agreed to go to the Kenai Peninsula Borough and ask their opinion on how to proceed with the comprehensive plan and the state statute. Her and I agreed on that. And that was supposed to have been passed on to everybody. And I never heard it mentioned again, period. Not in any hearing, not anywhere did I hear that mentioned. Her and I made that agreement. I kept my end of the agreement. And I went to the head of planning and the Kenai Peninsula Borough attorney both agreed I was correct in how the city should amend the zoning map by the authority of the comprehensive plan and simply amending the map. Just like you did in 2019, there was no advertisement, no nothing. You guys changed it from commercial marine to commercial business. I never saw the zoning on commercial marine, so I don't know what it looked like. I don't know what you changed. But I know you changed it in December of 2019. I asked the planning guy, his name was Robert. I said, how do I proceed? He said, to email the city manager and tell her to amend the map according to the comprehensive plan. I emailed the city manager twice and requested the amendment. And I've never in any hearing saw those emails show up. I never heard of those emails mentioned in any of the proceedings. If Randy was representing the city, which I believe she was, because she came to my house and called me out, the city didn't keep their part of that agreement, period. And I'm assuming she was representing you guys. I don't know. Maybe she was on her own time. The city manager and Randy insisted that an application to rezone was the only avenue, which seemed more of a variance than just amending the map according to the state statute. One of the justifications to rezone was parking. Did anyone ever go and measure any of the buildings on any of those 3 lots? Am I permitted to ask you folks? Did anyone go measure any of the houses, period? I'm assuming no one did. At least we didn't see anybody. Did anyone ever calculate how many off-street parking places were required by ordinance 18.28.030? Does anyone here know those numbers? Did anyone discuss how many parking places we needed? Well, I know those numbers. I have them. It's 1 parking place per 200 square feet of commercial space, and 2 for the residence part, plus 1 per every 4 employees. If you go to Mr. Lathine's house, he needs 11 parking places plus a 30 by 10 loading area to meet your own ordinance. Martin needs 9 spaces plus a 30 by 10 loading area to meet that. Strandic needs 9 plus a 30 by 10 loading area. Between the 3 lots, there are a total of 5 available spaces if Lathine tears out most of their landscaping. We might get 5 in there. Is the city prepared to supply those spaces, a total of 29 plus the loading spaces, to those 3 homes? Did the planning and zoning consider ordinance 18.28.010? Are any of you acquainted with UBC? Do you understand what that is? Unified Building Code. Been around since I started building over 50 years ago. And all the cities go by it, including Seldovia, all the states, they all, your husband being an electrician, I'm sure you understand that. If you would know that, you would know that none of these 3 buildings would meet the commercial standards, yet the city allowed them to be built, and these codes were in effect even in the 1980s when all those buildings were built. Are you willing to overlook the state statute and the 2 city ordinances I just mentioned, and are you prepared to take all the responsibility for them? After all, you are forcing them to be commercial. When asking one of the zoning members of the 2014 board that created the comp plan, the one that Mr. Sonnen just mentioned, when it came to those 3 lots, he said he didn't remember much. He couldn't tell me much about it. However, he did say we weren't going to throw Esther out in the street. I believe that was Mrs. Ent house, the house that Leslie's in. So I believe they did change that for her. Or I don't think he would have made that statement. Are we going to throw these other 3 folks out? Or do they not carry the same weight as Esther? The last part of your city manager's comment, there's no penalty if we don't follow that statute. Maybe you've already been penalized and just aren't aware, or maybe more like the folks of the citizens of taxpayers of Seldovia are being penalized. Number one, just the sheer cost of these proceedings. The discord it has caused within the neighborhood and the community. The future investment Leslie and I are no longer feel confident to put in Seldovia. Folks, we're not going to beg you to spend money here. I think Ms. Rojas and one other person didn't want any overnight rentals on the waterfront. And so what I've done, we've spent 5 months in New Mexico, and we had a long time to think about it. And I talked Leslie into taking that money and investing with me. We bought 1,300 linear feet of Rio Grande frontage property. Somewhere where we feel comfortable, we'll get it back. I don't know if the city doesn't realize that. We're not going to beg you. And I could go on. There are some things I believe that council members need to consider. The letters of opposition all use the same word obligation, as though they all came from the same source. The fact that the boardwalk easement was brought into this whole process, and I remember the words, I watched the video of the acting person. They want a zone change, we want a boardwalk. That almost sounds like extortion. Folks, how can you say your decisions weren't tainted? If you were my jury, you would have all been excused. If I was in trouble and you were my jury, the judge would have run you all off and say, let's get a new jury pool. I don't see how many things can happen and your decisions not be influenced one way or the other. The fact that one council member was so outspoken and probably should have recused herself. Her letter, along with the other 2, went to the very character of the 3 lot owners in a very defaming manner. That's my opinion of it. And it also seemed to me that the city manager and clerk were very one-sided against the 3 lot owners. What I watched, what I observed. I would have to at least question how this might bias the information that was given to you folks. I have a hard time believing that a jury pool wasn't tainted, just like I said before. We are prepared to take this to Superior Court in Homer. Maybe you will be able to convince a judge that this is just a wish list and that the state statute doesn't mean anything either. Either way, there's no winners in this whole matter. The damage has been done. One last comment I heard in the meetings. It's going to break my heart if it passes. I don't know if you folks remember that comment. Folks, it's been 730 tide changes since I was in front of you last. About a year. The things that break my heart is the amount of sewage that's gone in the slough each change of tide and the kids and folks that unknowingly play in it. The older woman that I watched fall flat on her face last summer, tripping on a rough, in need of repair boardwalk. You folks didn't see that, I did. A sweet retired couple from Wagoneer, Oklahoma, getting reprimanded for picking a handful of raspberries in the city right away on Bay Street. Do you think they will ever return or recommend anyone to visit Seldovia? Watching folks pay double or more to heat their homes. Seeing your lost opportunity on the most historic place in Seldovia. You guys will have to think about that one. I'm almost finished. You really care about Seldovia, maybe you should make them your priority. After all, this is the meat of your comprehensive plan or wish list. That's what you want to call it or refer to it. If you want to see firsthand what zoning is all about, why we have zoning, take a long look at 232 Fillmore. That real cute little log house, a picture of it's on page 32 of your comp plan. It kind of represent what Alaska is all about. Go look at it now. Set between two great big commercial buildings. Tell me what you think. How did that affect that little house? How did it affect the property values? That should speak for itself. You know, I was going to dispute a lot of their stuff in their letters, and I think you get the message. But there was one thing that Mr. Sonnen had told me. He confronted me on the street after that first deal, after they wrote the first letters, and he told me, he says, Walt, if you'll just go talk to the city, you could get by with a dadgum bubblegum machine. So to me, that discounts everything you said because you're asking me to skirt the law. You remember saying that?
I did say that.
You did say that. And by the way, I did look at some bubblegum machines when I was down in El Paso, Texas. I found a great old big one. Almost bought it. And I might ship it up here. But that tells me that some of this testimony just isn't very serious. And it was brought on by one of your board members, I believe. That's all I got to say.
Okay, thank you, Walt.
Thank you, Walt.
Mr. Mayor, if I'm, or Mr. Chair.
Yep, go ahead, Vivian.
Excuse me. Sorry, I can't be there in person. I just listened to that testimony tonight. My question is, I guess the comprehensive plan is what's in question here. That the city of Seldovia has not followed, the city council has not followed the comprehensive plan as the Martins believe it should be. And I guess I want to, I'm sure our city manager will probably rephrase how the concept of how we look at the comprehensive plan. But I think, I guess there's a question I have, a couple of questions. One, I think the parking situation and how much space is allowed for parking or parking is necessary. All through Seldovia, the city of Seldovia's let people, work it. We go bend over backwards trying to help businesses out, and the parking issue. I would question whether or not Mr. Barton has it totally clear, because I know that conversations come up within council, within the business district before, and other places. And maybe our city manager can address that sometime. But I believe there's a real issue here, and that is, one question I have to the Martins is, what is you want? The idea of having a residence and a business is what is allowable right now. And the city, as we've discussed, would bend over backward to help you accomplish that. But what I'm hearing is that you're very angry with the city, and that it's at this point, this juncture, you would rather just have a place that you can live in, and then if you want to have a business, you could do that. But the big question tonight is, what does the comprehensive plan really mean to the city and what do we need to follow? In the best interest of the city, what do we need to follow? And it's a working document, I believe, on my understanding. But that's all I have. Thank you.
Okay, thank you, Vivian.
Can I respond to that?
Yeah, no problems. Go ahead, Walt.
I have a question. We've been over this before, and nobody has explained to me the negative effect of rezoning from commercial to commercial residential. Go ahead.
So my understanding, yeah.
So that being said, and I said this before, I'd rather be part of something than all of nothing. And the 3 lots, and it's not about Walton Leslie, it's about what goes on in our community and what's in the best interest of the community. And my feeling is that you still have a commercial lot if the growth allows for the market to be there, people will buy it. I just sold commercial real estate, the residential, and it was easy to sell it because they could do either or. If they want to start a business there, they can, or if they want to keep it as a resident or whatever. But this town, I've been here when there was 2,000 people that was here, and now there's less than 500. And if you don't let the residents come in here, like I always said, you know, in the known gold rush, it wasn't the merchants that came first, it was the miners, and then the merchants came. And so it's important to have residents. If you're going to employ people in town here, they have to have a place to stay. And we're hurting for residential properties right now. That's all I have to say.
I'd like to address what Ms. Rowe asked me. What do we want? In the first place, in her letter, all those letters made it sound like Leslie's trying to relieve herself of her obligation. I hate that word, just bothers me, but we were prepared to build a couple of rooms. We got a lot of opposition. I don't think the council still decided on that. So that's still up in the air. But we're prepared to do commercial. If we don't win in Homer, we're prepared to do commercial, but it's not going to be those rooms. To answer your question, Ms. Rojas, we don't want anything at this point. We're prepared to put in, Jamie and I've already offered to rent most of that for office space in our ventures in New Mexico, a place to come relax and take care of our bookwork. And I've been talking to a couple of real estate companies. One thing I know for dang sure, real estate turns over constantly in Soldovia because people get discouraged and leave. I can make more money selling real estate, and I'm pretty dang good at it. I've probably sold more real estate than most of the realtors I worked with. So we're going to change in directions. We're too old to make beds or hire someone to come do it. And no one wants any rooms on the harbor anyway, so why fight it? A real estate office is a lot simpler, a lot less work for me. So we don't want anything from the city. We would like the city to go by what the statute says, is what we would like. This is the closest thing you've got to your word to the community. They spent a lot of money on this little comprehensive plan we've got out. That represents taxpayers' hard-earned dollars. If it's just a wish list, let's throw it away. But we threw away a lot of their time and effort. We would like, Ms. Rojas, we would like you to follow the comprehensive plan like the state statute says. And to be right honest with you, the comments you made to me about that, having to put it in, you were questioning me one morning a couple of years ago, and I could tell you were pushing my buttons. Mainly, we'd like to get out from under your thumb without being disrespectful. And I'm not talking about the city. I'm talking about you, Ms. Rojas. We would like to get out from under your thumb. So you take it for what it's worth, but that's pretty much it.
Okay, thank you all. Any other questions in regard to the opening testimony from Leslie Martin and Walt Martin before we move on to item G? Or excuse me, item H. Okay, hearing none, we'll go ahead and move on to item H. And this will be Heidi or Ms. Gagel's time to respond. And you also have 30 minutes.
Thank you, Mr. Chair. So I do have a response in front of me, and it's I'm going to try to quickly move through it and reference a lot of the packet. So I'll provide some page numbers, but I'll keep moving so we don't get stuck and I can make it through the whole statement. So as a municipality, I just want to remind you guys to start as a municipality, city council, staff, and as a whole, it is important that we operate and make decisions based on facts, laws, and ordinances, not opinions, feelings, mistruths, and misinformation. And it is your responsibility as the Board of Adjustment today to determine if the decisions made by the Seldovia City Council through Action Memorandum 2509, and that's located on page 36 of the packet, denying the rezoning application should be overturned based on facts and evidence supported by the Seldovia Municipal Code and Alaska law. And as the board chair stated, it could be overturned, remanded, or upheld. And so I'll provide some evidence based on those facts and findings, and then be available for questions. Starting off with the Seldovia Municipal Code, Chapter 18.97, Amendment Procedures. This is located on page 166 of your packet. This provides a process and procedures for an amendment of the zoning code and includes that the City Planning Commission shall hold a public hearing in accordance with the procedures and provisions as provided in Chapter 18.96 and shall consider and determine the following 7 criteria. Number 1, the need and justification of the proposed amendment. Number 2, whether the proposed amendment is in conformance with the comprehensive plan or will further the purposes of the plan. Number 3, the effect of the proposed change on surrounding properties or the area. And number 4, the amount of undeveloped land in the general area having the same district classification as that requested by the proposed amendment. Number 5, will it be reasonable to implement and enforce? Number 6, will it promote the present and future public health, safety, and welfare? And number 7, is it in the best interest of the public, considering the effect of development permitted under the amendment and the cumulative effect of similar development on property within and in the vicinity of the area subject to the amendment and on the community, including without limitation effects on the environment, transportation, public services, and facilities and land use patterns. I'm first going to speak to criteria 7, the best interest of the public. As evidenced by this packet and extensive timeline, the decision to deny the request to rezone was not made lightly, and ultimately did not have to do with the Seldovia Comprehensive Plan, which I'll get into in a little bit, because number 2 was determined by all parties to have been met, that this would align with the comprehensive plan. But ultimately, there was never enough evidence, and nor was there a consensus able to be reached or determined that the application met criteria 7. From the very beginning of this process, the applicants provided in their original application, page 121, that their reasoning for all criteria 1 through 7 is that their request to rezone aligned with the 2014 Seldovia Comprehensive Land Use Desired Future Conditions concepts. When the application was amended, page 123, it was provided again by the applicants that the proposed changes were beneficial to the public interest because they aligned with the 2014 Seldovia Comprehensive Plan and met community desires to have an expanded SLU district. I would like to point out here briefly that the city does not have a SLU district, nor is this alignment of properties with the neighboring zoning district on the SLU the only significant change presented in the land use desired future conditions concept provided in the 2014 Seldovia Comprehensive Plan. And you can see that on page 129, and we'll get into that a little bit more here shortly. In fact, when the Seldovia Planning Commission provided their recommendation to the Seldovia City Council during their July 24th, 2024 special meeting, page 105, to grant the rezoning request, the commission's attached findings included that for criteria 7, The public hearing provided an array of opinions, both pro and con, on what is in the best interest of the public. In that meeting alone, 3 public comments were made in opposition to the zoning amendment and 1 comment was made in support from an applicant. Additionally, 3 written comments in support and 3 written comments in opposition were provided in the packet. Those are page 131 through 139. Throughout the entirety of this process, the city received 20 public comments stating a position on the request to rezone that were either written or spoken during public comment periods. 11 were in opposition, 6 were in support, and 3 were from applicants in support. All comments can be found in the packet provided. Following the timeline after the recommendation to approve the zoning amendment was made by the Seldovia Planning Commission, an ordinance to amend the zoning map was introduced during the August 12th regular city council meeting, and a public hearing on the ordinance was held during the August 12th regular city council meeting, page 158 through 160. With the Seldovia City Council postponing the decision on the ordinance to the next regular meeting to allow all members of the city council and the city manager to be present. During the September 9th regular meeting, page 155, the ordinance was discussed by the city council, including the evaluation criteria number 7, best interest of the public. Ultimately, the decision to adopt ordinance 2502 failed with a vote of the city council, 1 yes, 4 no, and 1 absent, and a resolution denying the application was presented to the Seldovia Commission at the November 20th, 2024 special meeting. You can find those minutes on page 151. During the November 2024 Seldovia Planning Commission meeting, the commission moved to postpone taking action on the resolution denying the application to allow the Seldovia Planning Commission and applicants time to address criteria 7, and the Planning Commission chair provided a memorandum addressing criteria 7. During the commission's December 4th regular meeting, page 148, the memorandum was approved and forwarded to the Seldovia City Council with a request for reconsideration of the zoning amendment based on new information provided by the commission regarding that criteria 7. The memorandum can be found starting on page 67 of the packet, with a staff memorandum prior on page 63. The staff memorandum outlined the request, timeline of events, and new findings of the Planning Commission regarding criteria 7. Those new findings regarding criteria 7 were as follows on page 65 if you want to follow along with me. High-level findings with respect to criteria. In the best interest of the public, anything affecting the well-being, the rights, health, or finances of the public at large, the crux of the matter of best public interest is whether to retain the requirement for businesses along the port waterfront to preserve for the future, deny rezoning, or to align with the public interest expressed for the preferred land use defined in the 2014 Seldovia Comprehensive Plan, approve rezoning. Effective development permitted under the amendment. There are no undeveloped lots in the vicinity. The neighborhood has the character and appearance of a residential area. The cumulative effect of similar development on property within and in the vicinity of the area subject to the amendment and on the community. The change is one of classification from commercial business district to waterfront commercial residential district. The buildings on the 3 properties are already in place, with 1 operating a service business, non-retail, 1 supporting an existing retail business, and 1 remodeling to operate a lodging business. Rezoning would incorporate the properties into the adjoining waterfront commercial residential district, including without limitation effects on the environment, transportation, public services, and facilities and land use patterns. The rezoning would have no impact on the natural environment, transportation, nor pavilion, which is the only public service. Land use 3 commercial business district and the waterfront commercial residential district share 31 land uses in common. And that's in table B, you'll see in their packet. The transition from commercial business district to waterfront residential commercial district provides 21 instances of increased flexibility and 2 instances of increased restriction. And that's in table C of that packet. Additionally, the Seldovia Planning Commission provided a decision-making tool for the City Council, and that can be found on page 65. The request to reconsider with the memorandum was presented to the Seldovia City Council during their January 27th, 2025 regular meeting, page 56, and postponed by the Seldovia City Council until their next regular meeting to allow staff time to provide a draft 2014 comprehensive plan with strikeouts and additions, as well as items that needed further review or public comment for further discussion on the process for updating the Seldovia comprehensive plan. During the Seldovia City Council February 10th, 2025 regular meeting on page 51, the motion to reconsider the zoning amendment failed, and the Seldovia City Council directed a memorandum of the synopsis of council discussion with a completed decision-making tool for the approval and denial of the zoning amendment as suggested by the Seldovia Planning Commission to the Seldovia Planning Commission, and included the wording non-consensus under criteria 7, as well as a comment reference during public testimony in one of the two work sessions held prior to the KPV Borough Planning Director's comment that had been provided that there was nothing to compel the city to follow the plan. In the end, the zoning amendment application was denied by the Seldovia City Council through Action Memorandum 2509, page 36, at the February 24th, 2025 regular City Council meeting, page 46 for those minutes, due to a lack of consensus and unresolved concerns regarding Seldovia Municipal Code 1897 Amendment Procedures, B7, Best Interests of the Public. The fact that the request to rezone aligns with the 2014 Seldovia Comprehensive Plan, I would like to remind everybody again, is not in dispute, though the reason it is in the comprehensive plan could be. In fact, throughout the entirety of this process, as I mentioned earlier, criteria 2, whether the proposed amendment is in conformance with the comprehensive plan or will further the purpose of the plan, has been considered and determined to have been met by both the Seldovia Planning Commission and the Seldovia City Council during their findings of fact, again, page 106, and the synopsis of the City Council decision, page 38. Additionally, criteria 2 through 6 of the Seldovia Municipal Code 1897 Amendment Procedures were considered met by both the Seldovia Planning Commission and the Seldovia City Council. A project titled Comprehensive Plan Zoning Code Update and Review has been included in the Seldovia's capital improvement plan for multiple years to emphasize and ensure compatibility between the Seldovia zoning code and comprehensive plan. This is a known issue by the Seldovia City Council. As is the alignment of property zoning is not the only significant change shown in the desired future concepts. If you will look at page 129 of your packet, this is page 33 of the 2014 Seldovia Comprehensive Plan. In fact, if you examine that diagram further, you'll note that none of the preferred future land use scenarios match the existing zoning code by name or size, including the SLU district. And the concept includes unzoned areas outside of city limits. In essence, to align with these land use scenarios would be a massive undertaking that could include annexation and may not align with current desires and preferred land use scenarios of the community today, which is why it is prudent that the city seek public input regarding the 2014 comprehensive plan and provide an update to the plan based on that input provided and what the city can realistically undertake based on scope of powers and jurisdiction of municipality. Regardless, the request to rezone does align with the 2014 Seldovia Comprehensive Plan, and I'll say again, is not in dispute. The zoning amendment failed because of the not because of the comprehensive plan, but because all the criteria were not met as required by the Seldovia Municipal Code, specifically criteria number 7. In fact, the determination that this zoning amendment is in the best interest of the community was so disputed that during the Seldovia City Council discussion, members of the council called into question if criteria number 1, the need and justification of the proposed amendment, was even fully met, as evidenced in the synopsis of the City Council discussion decision-making tool. And again, that's a page 38. Also on that page 38, under City Council finding denial, the City Council provided that properties were purchased with the intent to be a business, are attached to or plan to be attached to a business, and property owners spoke of their intent to not change their purpose regardless of the zoning change. No need or justification were provided other than the amendment aligned with the desired future land use map provided in the 2014 Seldovia Comprehensive Plan. Also, while the Planning Commission finding for criteria 2 was accepted, it was noted on the synopsis that there was a lack of confirmation in the community, public, and 2014 Comprehensive Plan that there was a desire now for these properties to be rezoned as provided in the plan 11 years prior, as many comments received actually supported the opposite. It was also noted under the City Council finding denial for criteria 3 and in the amended finding of the Seldovia Planning Commission for criteria 7, that while the properties in question would align with the surrounding zoning, which was less restrictive, they also align with their current zoning. Additionally, multiple comments, public comments in support of the zoning minute have been provided that speak to the nature of the buildings and area aligning with residential uses. While this is true, this area has been zoned for commercial purposes along with the waterfront side of Main Street since 1966 as part of urban renewal, and the nature of the buildings also aligns with those buildings on Main Street throughout the commercial business district. Property owners have never been restricted from building residential type buildings with the exception of single family homes in this district, which is the commercial business district formerly known as commercial marine, as long as they were primarily used for a commercial purpose. And during recent discussion with the Seldovia City Council regarding land use types in the district, it was again clarified that residential buildings, aka dwelling units, should be allowable as long as they're not single family homes and they were primarily used for commercial purpose. The onus has always been on the property owner to ensure that their building meets that primary purpose, regardless if it is a residential building, as they're in a business district and the business comes first, and business can take place in residential type buildings. I would also say to Mr. Martin's comment that the onus is also on the building and the property owner when they build a building in Title 17, that they're following building codes. We do not provide building inspections like a lot of other small communities, and it's on the building application that they follow those codes. It has also been stated and I'll skip that part for now. It was also suggested by the appellant in their letter of appeal, page 9, that the zoning amendment request was processed as a variance that was suggested by the city manager. As a city manager, I was the one who handed the applicants the zoning amendment application petition shown on page 121 and suggested that this was the appropriate process for the applicants if they did not want to wait for the planning commission to revise and update zoning codes and the map in response to the comprehensive plan vision, which, as previously discussed, would be a larger public process that would impact every zone and potentially outside of city limits. Variances, conditional uses, and zoning amendments each have their own set of procedures provided in Seldovia Municipal Code. And it would not have been an appropriate avenue for this process, as it would have required applicants to prove that they need relief from the literal enforcement of the code, depriving the property owner reasonable use of their property, of which financial hardship or inconvenience cannot be the reason to grant the variance, along with meeting the rest of the conditions provided by Seldovia Municipal Code 1876 variances. However, the city council did discuss a sunset clause or a moratorium that would allow the property owners to be a primary residential use until the property transferred hands, similar to a conditional use. Regardless, there are longstanding processes for each procedure provided by municipal code with requirements that are required to be met by the applicant. I would also furthermore state that the Seldovia Comprehensive Plan, thank you for bringing that up, Mr. Martin, on page 1, does say that the Seldovia Comprehensive Plan is a framework to guide development and strategic community investment over 10 to 20 years. It represents a broad community vision defined by residents during a 2013 public process. This document also provides the legal basis under state law for adopting land use regulations. Again, that's page 1 of the comprehensive plan under A, plan review. However, as stated, it does not require implementation. And this is important because your plan has so many things in it, including annexation, that if you just went and implemented willy-nilly because it was in there, you would have a blow up from the public. The public process is extremely important. And as you can see in Alaska statute, which is provided in the packet under page 144 and 145, that Alaska Statute 2940.030 Comprehensive Plan provides that the comprehensive plan is a compilation of policy statements, goals, standards, and maps for guiding the physical, social, and economic development, both private and public. Under Alaska Statute 2940.040 Land Use Regulation, in accordance with a comprehensive plan adopted under Alaska Statute 2940.0030, and in order to implement the plan, the Assembly by ordinance shall adopt or amend provisions governing the use and occupancy of the land that may include, but are not limited to, 1, zoning regulations restricting the use of land and improvements by geographic districts. 2, land use permit requirements designed to encourage or discourage specific uses and construction of specific structures or to minimize unfavorable effects of uses and the construction of structures. 3, measures to further the goals and objectives of the comprehensive plan. And then there's more on variances. I would say some key takeaways from that Alaska statute 2940-040 that were pointed out, have been pointed out now by both parties, are that in order to implement the comprehensive plan, the council by ordinance shall adopt or amend provisions. Meaning, in order for a zoning amendment to take place, whether an application by a property owner from the planning commission or the Seldovia City Council, an ordinance is required to be adopted. As with, just because an item is in the comprehensive plan does not mean it has already gone into effect. And as with all matters of municipal business, the public process is paramount and of utmost importance, which is why the process for ordinance is provided by both Seldovia Municipal Code and Alaska Statute 2925-020 Ordinance Procedure, including number 5. During the hearing, the governing body shall hear all interested persons wishing to be heard. And number 6, after the public hearing, the governing body shall consider the ordinance and may adopt it with or without amendment. They may adopt it. Just a couple, since I have a few minutes, I would like to just address a couple items. The first and foremost, Seldovia City Council members, staff, and Planning Commission members cannot act individually on behalf of the city. The individual decisions, or through individual decisions, the decision comes from the body. It's going to come from the body of the Planning Commission. That's going to come from the body of the council. And then those decisions are passed down through administration and made. So, I will also say that as for the emails, those are a public record with Robert and can be disclosed if warranted. Or it's not with Robert, sorry, from Mr. Martin to myself. I did follow up with Mr. Martin and clarified that the process for amending a zone is in code, Amendment Procedures 1897, and provided them that application, as I said prior. That is the process to amend the zone, and it was provided. Robert, the planner for the Planning Commission, who Mr. Martin spoke with, did follow up with me, and he stated that he also had followed up with Mr. Martin to let him know that we did have a procedure, and that if they wanted the amendment to happen, that they should follow Seldovia code and work with the city to complete that process, as well as that statement that there was nothing that compelled us to follow the comprehensive plan, which is why the processes needed to be followed. Lastly, I would also say in terms of parking, we would have to look at that separately because that really depends on how you're using your space. If each zone has its own parking regulations, and it depends on what land use type you're utilizing for what your parking would be. And that would be a potentially an appropriate avenue for a variance request if you weren't able to meet parking. There is a precedence for that in this community. But again, that depends on your land use type, what you're utilizing that property for. And I did have one more thing. I would also want to point out that as for the boardwalk easement that was mentioned, you can see that on page 106 of your packet, that the commission did provide a recommendation to the city council that the rezoning request be granted and ask staff to determine if it's appropriate to add a requirement for a boardwalk easement as part of the rezoning. Staff did ask legal counsel and was informed that that would not be appropriate, and it didn't go any further. And that was provided to the council in a follow-up discussion. In closing, in the end, there's been a lot of misinformation surrounding this zoning amendment request and process. However, the facts and evidence remain the same and are provided in this packet. And while the application was determined by the Seldovia Planning Commission and Seldovia City Council to have met criteria 2 through 6, including item 2, whether the proposed amendment is in conformance with the comprehensive plan or will further the purposes of the plan, it was thoroughly considered but never determined that the amendment met criteria number 7, that it is in the best interest of the public considering the effect of development permitted under the amendment and the cumulative effect of similar development on property within the vicinity of the area subject to the amendment and on the community, including without limitation effects on the environment, transportation, public services and facilities, and land use patterns. Furthermore, 11 out of 20 public comments were spoken in opposition of the amendment being in the best interest of the public. And Number one on the council synopsis, decision-making tool indicates that proposed changes may not be justified. And number three, that aligning with the surrounding properties would be less restrictive for property owners, which would have an impact, including setbacks, parking, and building heights. All of this to say, as shown through evidence provided in your packet, that the zoning amendment failed because it did not meet the criteria provided by Seldovia Municipal Code to be in the best interest of the public, nor was it determined justified. And the decision of the Seldovia City Council is grounded in public process, written findings, and municipal code, and should be upheld. Thank you.
Thank you, Heidi. Thank you, Heidi.
Mr. Mayor,
Yep, go
can we have a
ahead.
can we have a recess?
You need a recess for a few minutes?
Yeah, please.
Yeah, we'll go ahead and, let's go ahead and take a 10-minute recess.
Sounds good.
Liz, just let me know when you guys are ready to get started again.
It looks like Chair Campbell that everybody is ready to resume.
Okay. All right, we'll go ahead and come back to order here from our break. So we had just left off on, let's see here, item H. Ms. Gagel had testified for 30 minutes with her opening response. Was there any questions or comments for Ms. Gagel before we move back to the rebuttal phase of this?
Yeah, I do have a rebuttal on a couple of things. Yeah, my response to Heidi. Did you receive my emails where I asked to amend the map? I sent 2 emails prior to any of this application.
Are we supposed to? Is this a back and forth time right now, Mr. Mayor? I thought this was Mr. Board Chair. I thought this was a time for the board to ask questions.
Yeah, so if there's, let's just clarify, if there any questions, or if there's none, then we can go ahead and start the rebuttal piece back to Leslie's side with, and then if Walt wants to take it, that's fine. Okay, hearing none, then go, sorry, go ahead, Walt, you can go ahead and get started.
Sorry about that. I guess I missed that. Okay, I guess it's all right if I ask Heidi these questions.
It's regarding her rebuttals or her statements, so if we have questions about it.
Okay, I'll go on. First off, when I went to see Robert in Kenai Peninsula Borough, he told me he thought I was correct in the way we should amend this map and follow the statute. He said he wanted to run it by his attorney. And that was the end of our conversation. I went on about my business. I never got a call back from Robert after that. In regard to what Heidi just said, I finally called Robert up and I said, hey, what was the outcome? He said, well, you're correct. And my attorney agreed with it. And I said, how do I proceed? He said, send the city manager an email requesting to amend the map. There was no discussion about the city process. He told me that I was correct in the way I read the state statute and how to handle it. He also had told me one thing when I was visiting with him in Soldotna. He said the borough had already amended their map to match our comprehensive plan. I don't know why he said that, but he did. And he did seem, when I called him, he told me he had been in contact with Heidi and he was pretty quiet, but he did say that I was correct. And the way to handle it was to send Heidi an email, and I sent her 2. And then we got off all into this variance and all this other stuff, and against our will. I think she had met with Stranik and he came with this, said, and then took it and had Lathine sign it, and they put a lot of pressure on, say, you got to sign this or we can't proceed. And all the time I kept telling them, I said, no, I've already got instruction from the borough. So I highly dispute what Heidi had just said about Robert discussing anything about the city ordinances with me. That never happened. One other thing I would like to read in one of the letters that I'd missed. And this came from Sachiko Scott. If these petitions come through, won't it be easier for the owners to sell their properties? I gotta tell you, that scared me. As an investor, as someone that buys, sells stuff, it almost sounds like we're condemned over there to a lower level of property values. I think that's something we all probably ought to think about on that one. Leslie, did you want to go on with yours? Or do you?
I had a couple things that I from when Vivian was talking about talking about the parking, that everybody in the city has a problem with the parking and everybody's getting a variance, everybody's getting like pretending that it's okay and that we're just like living around it. And my thing is that we're being asked to be relieved of that and move out and not have to come up with 9 parking spots. Everybody, we're kind of like being forced to stay in commercial. So therefore we have to deal with those parking spots, whether or not the city wants to deal with it or not. It's still there. It's still an ordinance and it's still on the books. That's never going to go away, even if we want to close our eyes and not think about it. And the other thing was about number 7 being the reason why we got shot down and got a fail. And I had written Heidi and the planning and zoning when we decided that we were going to do one more shot at trying to figure out if there was some common ground that we could go that way instead of going to the appeal like we are now. Was that try to regroup on number 7. And number 7 was in the best interest of the public, and everybody seems to stop right there. Like that's the be all end all. What does the public think about what's going on over there? Well, that's not what number 7 is talking about. Number 7 is talking about the development. How is the development going to affect the area? Well, the development is not going to affect the area because it's been there for 20, 30, 40 years. There's not going to be any change. The only difference is that I've got new siding and the traffic is not going to change. The environment's not going to change. The building's not going to change other than a new facade. Nothing about that is going to disrupt the interest of the public. And I guess I kind of get ticked off when everybody refers to number 7 as asking how this is going to affect the community. And I'm going, that's just a precursor to the actual question about the development. So everybody gets all riled up about this is really going to ruin everything and we're going to have to, our interests are going to be diverse, that nobody's going to agree, and then we're always going to be in an upheaval. And I don't understand that because nothing is ever going to change. If you went by there today and you had rezoned us, there wouldn't be any difference. You would still go up and down that street. Nothing would be changed other than a map. There's nothing is ever going to happen there other than what's already there. And I guess I don't understand how that would be not in the best interest of the public. Why are they being affected by this? I maybe somebody needs to explain that to me. I'm not sure.
I think I would like to clarify a little bit what she said, because so I understand it better. It's asking the effect of the development is going to have on the public, not the opinions of what the public has to say. And if there is no development, there is no. Am I reading that right?
That's what
It says right there. Not the opinions of all those people that have an opinion about it. If there's no development, there's no effect. I just wanted to clarify that so that
there is no development.
it says it right in your
They have.
instructions.
I guess that's all I have to say.
Jeremiah.
You're on mute, Jeremiah. You're muted, Jeremiah.
Yeah, sorry about that. Yep, Heidi, you also now have 10 minutes to rebut on behalf of the city.
Thank you, Chair. So, in regards to Mr. Martin's question about the emails, I do believe I remember receiving them. And I also remember speaking with you and going out to the truck with you and handing you an application for the amendment to rezone. And an email, a request is great. We get requests all the time. However, there is a procedure and an application process that allows that request to move forward. Simply stating something that you desire in an email doesn't allow that process to move forward into the Planning Commission zone realm, which is where it needed to be. So that was the vehicle and why I provided it, because I was responding to and respecting that request to want to change the zoning map. So providing that to you was the vehicle to provide that process. And I tried to look for those emails, but my internet was slow. So I can try to find those in a little bit, but I do remember, I believe, receiving those. So that process, again, is provided in 1897. That's before my time and before I think anybody sitting on this board's time here at the city that process was developed and provided to the applicants. Parking, as stated, that could be an applicable variance and something that could be addressed moving forward. The city of Seldovia is a very unique community with a lot of nonconformities and variations, platted roads that not platted roads that don't exist, and roads that are not platted that do exist, and it was built after urban renewal, kind of here and there, but we do our best to follow through and move forward and follow code. And with regards to number 7, you can see that is on page 167 of the packet, chapter 1897 amendment procedures. That it does state and is in the best interest of the public, considering the effect of development permitted under the amendment and the cumulative effect of similar development on property within and in the vicinity of the area subject to the amendment and on the community, including without limitation effects on the environment, transportation, public services, facilities, and land use patterns. And was not fully addressed. And the Seldovia Planning Commission did address it to the best of their ability. And in the end, when the synopsis went back to the Planning Commission from the what's up here, council, not only was that not addressed, but it did also state that there was an impact on criteria 3. Here on page 38 of the packet. So criteria 1, that the justification, there wasn't a justification provided or need provided other than it is in the comp plan. And number 2, that Planning Commission finding accepted. However, there's a lack of confirmation as discussed. And it also states a comprehensive plan and zoning code update and review has been discussed for several years and is included as a priority in the 2024 and 2025 capital improvement plans with a desire to emphasize and ensure compatibility between the Seldovia zoning code and comprehensive plan. Number 3, properties are currently aligned with existing zoning and would align with surrounding zoning, which is less restrictive. Properties are mixed use, commercial, residential, and are attached to or plan to be attached to business and do not intend to change purpose. And you'll see that it goes into setbacks are decreased. You know, there's a variety of changes here. The purpose is less restricted and only and includes residential use only. A long-term residential permit would no longer be required for residential rentals. A 5,000 square foot minimal lot would no longer be required. The WCR has no minimum lot established, but includes open space requirements. Parking requirements remain the same and depend on residential or commercial use. Setbacks are decreased 10 feet from the road to 5 feet from the road and remains the same at 6 feet. So buildings can be expanded and built larger. A requirement for deck or dock setback in the small boat harbor would need to be added to WCR. Maximum building height changes from maximum building height is 28 feet measured from the center line of Main Street to not exceed 28 feet from where the final grade meets the average of the highest foundation corners and to not exceed an overall height of 38 feet. Land use changes include secondary use permitted. And then you'll see the variety of permitted to not permitted, and then the two from that are more restrictive. So there are changes that would occur, and there are additional changes that would need to happen in code regarding height. And there was one other item. Decks and dock that would need to be addressed, because this does have an impact. If a rezone happens, it does have an impact. And so when it comes to terms to item 7, I can't address that. That is up to the applicant and to the body. But it is shown in this packet that there is an effect, and if it needs to be considered further for that development, maybe that's a direction to move forward. But regardless, it can stay the same now. We don't know what it's going to look like in 10 years. I can't address that for this body. All I have is what is within this packet and within our code and within Alaska statute. And that is that the number 7 criteria was not met and called into question number 1 criteria, and that there is an impact that is noted under criteria 3. Thank you.
Okay, thank you, Heidi. Does anyone have any questions for Ms. Gagel before we go to closing arguments? Heidi, I have a quick question for you on number 7. And this is just, maybe we talked about this before, but the criteria themselves, where does that come from? Was that copied from somewhere in a state statute, a borough code? Any idea where those where the criteria and the wording comes from?
I could not speak to that.
Okay. I'll just make a comment. Yeah, it just seems like number 7 is that's been the crux of this whole issue during the appeal process. We've had a number of discussions on that, and yeah, the way it's worded, it's kind of it's basically set up for failure when anytime you're going to have call into the best interest of the public, because it's going to be 50-50. Unless it's something so overwhelming that everyone's going to agree. But I mean, clearly we can't even agree on free money from the state and how much that should be. So if you can't agree on free money, how are you going to agree on what's in the best interest of the public? So yeah, we have a lot more discussion on that, but I was just curious where the wording came from. So all right, if there's no other questions for Ms. Gagel on her rebuttal, then we'll move on to the final piece of this. And this is item K. This will be closing arguments. Leslie, if you have anything in final that you or Walt want to say, you have 10 minutes, and then we'll move on to Ms. Gagel's closing, and then get this wrapped up.
Well, I don't know what else I can say. I've said everything I've said here tonight has been said by me in email after email and meeting after meeting. Nothing about this whole thing for me has changed. So I don't think there's anything more I can say. If I haven't said it by now, nobody's ever going to get it, and nobody's ever going to understand where I'm coming from. So I don't know. I don't have anything else to say. Walter, do you have anything else?
Yeah, I'm still wondering why the borough attorney and the planning guy would step out on a limb and tell me what they told me, because it's direct conflict with what the city has said. And I have talked to a personal attorney, and they said the same thing. So I have 2 attorneys and a planning director in Kenai saying one thing, and I have the city saying another. the weight of my belief is going to go with the borough and another attorney. I don't know what else to say other than that. I think that this whole thing has been opinion after opinion after opinion. When I came here in 2014, that house was vacant for almost 8 years and everybody was happy with that. An old faded house. And then I bought an old junk house on the harbor and the slough that was falling in. I've never been in a place where I fixed 2 places up and got so much opposition. And that's okay. I'm not asking for nothing. I mean, we would like you, like I said, we have land. There's a lot more in this plan than just the land. There's the little church on the hill that no one's paying attention to. Has anyone been up there and looked to see what it looks like today? The boardwalk that I spoke of, I mean, thing after thing after thing is in here. And in the 10 years that I've been here, nothing has been done. Zero. And everybody in these letters alluded to the fact that me and Leslie knew all about this house going in it. I bought it from the owner. We never discussed the zoning or anything. I knew that the precedents had been set. That's been a resident for 35 years. Sort of like adverse possession or that type of thing. It's been a resident since it was built. And one of the questions I asked Mr. Sonnen is like, well, did you complain to the previous owners? I never got an answer on that. Folks, if we're going to go with personalities, I'm not going to win. So I'm pretty outspoken. I say what's on my mind. I don't beat around the bush. It is what it is. And that's fine. You know, this is a big old state, Alaska. If I have to have something in Alaska, I mean, it's a big old state. I just hope you do the right thing, and it's not because of personalities or a little group down here that got together and did what I call lynch mob politics. They get on the phone and, hey, we got to write this letter. And I think Mr. Sonnen admitted that he was asked to write that letter. I call that lynch mob politics. You can call it whatever you want. That's all I got to say. That is a lot of it.
Okay, thank you all. Thank you, Leslie. Thanks for your closing arguments there. We'll go down to Ms. Gagel. You also have your 10 minutes to make the final closing arguments on behalf of the city.
Thank you, Chair Campbell. I just want to reiterate to the members of the Board of Adjustment that you're tasked today not with reevaluating preferences, opinions, or intentions, but with determining whether the Seldovia City Council erred in its application of municipal law, specifically Seldovia Municipal Code Chapter 1897, when it denied a zoning map amendment through Action Memorandum 2509. Throughout this process, both the Seldovia Planning Commission and the City Council engaged in extensive deliberation on the required criteria under Seldovia Municipal Code 1897-010B, and ultimately the application was denied on the grounds that Criterion 7, whether the zoning amendment was in the best interest of the public, was not met. For that, Criterion 7 requires a determination of whether the proposed amendment serves the present and future public health, safety, and welfare, taking into account the cumulative effect of similar development on surrounding property, the community, the environment, transportation, public services, and land use patterns. The applicant cited alignment with the 2014 Seldovia Comprehensive Plan as evidence the amendment was in the public's best interest. However, this argument rests solely on the land use map concept on page 33 of that plan. Importantly, the City Council received 20 public comments, 11 in opposition, 6 in support, and 3 from the applicants. In support, this reflects a community without consensus. The Planning Commission itself acknowledged in its findings at the July 24th public hearing that there were an array of opinions, both pro and con. Despite the commission's subsequent effort to provide a new analysis and a decision-making matrix for reconsideration, the city council concluded by memorandum that they had not overcome the central issue, a lack of compelling evidence that the rezoning was in the met criterion 7. It is not being disputed, however, that the zoning request aligns in part with 2014 comprehensive plan. However, alignment with the plan is only one of those 7 criteria, not determinative on its own. The plan itself is conceptual, aspirational, includes zoning designations that do not currently exist, such as SLU district, and envisions land use changes beyond city boundaries. As noted in city discussions, adopting these concepts whole would require a full zoning code update and annexation discussions, and that the city has already noted in its capital improvement plan that the comprehensive plan and zoning ordinances may need to be updated and reviewed. So with that, I would also provide that also has a large public hearing process, and that in the end, that is really important that we do follow our processes and that we do allow time for that public input. Thank you, thank you, Chair Campbell.
Okay, thank you, Ms. Cagle, for your closing arguments. Do any at this time, do either parties, appellant or appellee, have any questions, additional questions to the members of the board?
Did you repeat that? I didn't hear that.
Yeah, do either party, either yourself or Ms. Cagle, do you guys have any additional questions for the board members?
I do.
Okay.
Were any of you guys aware that Randy and I had made that agreement? Did anyone tell you that? No, I didn't think so. But we did make that agreement, and I wish she was here because she seemed pretty helpful at the time. And were you ever given the statistics on how many parking places we needed? 20, I think I came up with 29 places plus 3 loading areas. Did anyone ever get that information?
Mayor Campbell.
Yeah, go ahead.
I didn't have that particular information, but I do know that there's an issue with the parking. There's an issue throughout the whole community.
Well, the thing about that came to my mind on that very issue, John, was we're being asked we want to be, we don't want to be commercial anymore. We don't be held to that standard that we have to have 9 parking spaces. Everybody else in town, you and other businesses have to put up with that because, there's no other way around it. I have another way around it, but I'm being opposed and not allowed to rezone. So I'm kind of feel like I'm being forced to be commercial and forced to have to deal with that. That's my difference in everybody's parking problem. That's the only difference I see in it.
Well, I get it, and I appreciate you guys' testimony today. Thank you.
Okay, thank you for your response, John. And okay, with that, that will conclude the oral arguments for today's hearing for this Board of Adjustment appeal hearing. What will happen next is we will go into the board's deliberations. Deliberations may be held in public or in an adjudicative session. A written decision will be prepared and issued to the parties at a later date after deliberations are completed. Copies of the written decision of the board will be mailed to the appellant and all other parties who entered an appearance in the appeal. Once a final decision has been entered by the board, an appeal from that decision may be taken directly to the Superior Court by a party who actively and substantively participated in the proceedings before the Board of Adjustment or by the city manager. That appeal must be filed within 30 days of the date of distribution of the final decision. And that references Seldovia Municipal Code, section 18.92, .060. At this time, I would entertain a motion then to adjourn the public portion of the Board of Adjustment meeting. And then after adjournment, board deliberations will commence and continue as needed until completion.
Motion to adjourn.
Second that.
Okay, we have a motion to adjourn the public portion of this meeting by Rojas. We have a second by Langbart. And we'll go ahead and call for a roll call vote on that. All those in favor, Rojas,
Aye.
Kennedy,
Here.
Peyton, Keithley,
Aye.
Langbart,
Aye.
and Barber.
Aye.
Okay, motion passes with 6 in the affirmative. So that adjourns the public portion of the meeting. And I would like for after the public leaves, I'd like the city attorney, Joe Levesque, to stay in, and then the city clerk, Liz, because we're going to have to capture notes, and then everyone else can be excused. Okay, thank you everyone for participating today. Yeah, said definitely a precedent, first time for everyone.